42 of the Inland Empire Workers' Compensation Lawyer live stream podcast. My name is Attorney Alexander Napolin. I'm joined by my co-host, Attorney George Abuado. And on this episode, we're discussing returning to work after a work-related injury. So if you're out there and you've been injured at work, you might get a return to work slip with some work restrictions on it to go to your employer for temporary modified duty, or you might receive a permanent work restriction and you're going to your employer for a permanent modified position. And that's what we're discussing on this episode. We're having a general discussion about what the injured worker should expect and what their legal rights are. And if you have questions, we encourage you to dial the injury helpline. That's 844-984-8414. And you will receive a free and confidential case evaluation if you're an injured worker in California and you need help getting legal advice. What we're discussing is not legal advice. It's just a general discussion that's going to help you understand the rules around returning to work after a work-related injury, what to expect.
This is a very good topic because a lot of people get this notice and they say, I don't feel well enough to go back to work. However, you have been deemed okay to go back to work, at least partially, maybe with some restrictions, by your primary treating physician or by the QME, Qualified Medical Examiner, the neutral doctor that we always talk about.
You're at the industrial medical clinic. You've been given a work status report. We call it a PR2. It could be, it's your primary treating physician's report about the status of your health. And it's going to have, your conditions on it. It's also going to list work restrictions. You're required to bring that to your employer and give that to your employer and ask for an accommodation under the law. And then your employer is required to offer you modified work or tell the insurance carrier that they cannot offer you any work because they don't have work within the restrictions.
Right.
Now, what George is discussing is a lot of times you go to your employer and you provide them with the paperwork and they say, okay, well, we have a modified position for you. And they get you going on tedious tasks that closely resemble, abuse maybe, or they're sending you to a remote location, changing your work site. You might disagree with those actions.
Right.
You might need to go back to the doctor and discuss, hey, this is what they're having me do now, and I'm having issues and I need additional restrictions.
Right.
And George and I see this all the time. It's something we discuss when we get together. Hey, these employers are doing these things. So that's one of the reasons why we're putting this episode together, to give you this education.
Yeah. Now, sometimes, and I don't know if this has happened to you, I'm sure it has, Alex, with all the people you've helped, it's the actual patient themselves, the injured worker, the applicant, that requests for restrictions to be lifted so they can go back to work.
Yes.
Have you had that happen?
Yes.
Okay. So when that happens, obviously, if you're going to request that from your doctor, definitely speak to your attorney about if that's a good idea or not. You are the one requesting that the doctor provide a report that you can work with no restrictions. So now, several things can happen further along in the claim, and we're going to, kind of just discuss them briefly because we might do another video on them, but it could greatly affect your claim. These restrictions being lifted now are going to go into the final report. Now you seem like you're doing better. Now you're not as hurt as you were before, but you want to go back to work. So I wouldn't say lying, but you're making the doctor issue a report that he might not be 100% in agreement with.
Right. Well, the doctor might think that you need more time off and you might want to go back to work because you're bored at home or you aren't making as much money because temporary disability isn't a full wage replacement. It's only 2/3 of your gross pay. So there's a lot of reasons why you might want to push yourself beyond what your doctor wants you to do in the course of treatment.
Right.
And you need to discuss that with your lawyer because your lawyer can be a good counselor on what that means for your legal rights and how that could change your claim. Like George mentioned, if you're still injured and you want to present yourself as better than you really are, that's going to potentially limit your permanent disability.
Right.
If you later change your mind and you say, well, I really can't handle it, now you might not be able to get back to temporary disability. That's going to cut off a lot of your benefits. So you need to have your a good understanding of what you're doing before you go and just have yourself released back.
Right.
And that's why you need to dial the injury helpline if you need legal advice. This is general information only. It's meant to help you. It's meant to make you aware of the issue. Hey, what are my rights for returning back to work after a work-related injury? But it's not educating you as to what all of those rights are. You need to get legal advice.
Right. So, Alex, once you get that report from your doctor saying you can go back to work, but you might have some work restrictions, is there a process that the employer has to undergo in order to bring that employee back to work and make sure that everything's accommodated for them?
Oh, yes, absolutely. Employers in California have to follow a long list of protocols in order to properly evaluate whether or not they have accommodated work for you or not. And it goes both ways. I mean, an employer could terminate you for not showing up to work, or the employer might have you back at work, and now they're trying to get more restrictions on you to get rid of you. So you need to be aware that you have rights and that that your employer has to be following protocols.
Right.
I mean, if they're not doing that, and then you definitely need to call an attorney.
Yeah, and I will take a quick minute to talk about something that is not directly related to today's video, but it's very important. Just because these reports are very important. They need to be dealt with quickly. Notices and letters from the employer and the adjuster also need to be responded to. Maybe not by yourself if you have an attorney, but they definitely need to be responded to by the person that's in charge of your case, your attorney, or if you don't have one, then by yourself. Sometimes the employer will send a letter out saying, you've been off of work for a while. We can't. You have no more time off left. Maybe they're using your FMLA incorrectly to have you off of work, and they say if you don't respond by this date, then your employment will be terminated. If you don't respond to those letters and you say, hey, this is not right, I'm off because of workers' compensation. It's not just that I'm off. My FMLA shouldn't be used. You shouldn't let go of me. I still should have a job because I'm out because of a work injury. If you don't at least let them know that and you don't respond, then that's deemed that you've abandoned your job. And so now you can't go back and fight about that. I mean, it's going to be very hard to get reinstated. It's going to be very hard because you had a duty to let them know that you are still eligible to keep your job because you're on workers' compensation. But it's very important that you take these notices and give them to your attorney if for some reason they haven't gotten it. Now, I will note that most of the time we get the same mail that you get. So if you have a question, reach out to your attorney. But make sure that you respond to every single letter that needs a response. Not every single letter needs a response, but if it's something that's important like that, like they're telling you you will be let go from your job if you don't respond, obviously that's something that you need to respond to, right?
Yeah, absolutely. If you're not working and you need to stay in communication with your employer,
right?
I mean, that's that's something that is important for your case, and it's important even if you have a workers' compensation lawyer.
Right.
So if your employer is if you're off of working, you're not working, you need to be having a doctor writing you notes, and you need to be bringing those to your employer to let your employer know that the reason why you're not working is because you're injured. And if your employer is doing anything improper, you might not know it. But if they're sending you formal stuff, that means they're probably following a protocol. And if they're following a protocol, that means that they're treating you consistently with all other employees potentially. And that means they're just gearing up to do the fire at the end of the protocol.
Right.
So if you don't stand up and you don't push yourself and inject yourself into that situation and you just let it go by, yes, you do have a couple years to sue for discrimination. Actually, you have 1 year under California Labor Code Section 132A, which we've discussed on this channel, which is discrimination for filing a workers' compensation claim. But there's also time limits under the Fair Employment Housing Act and other disability laws, and they can be quite short. And even if you meet those time frames, if you don't do the right thing in the moment, you don't create the case against the employer that you would otherwise have. Because maybe if you're not delivering them doctor's notes or you're not communicating with the employer, that alone could be a reason for termination. And now you've just given up your rights, and we do see that as workers' comp lawyers.
Right. All right. So a very good point, Alex. So what type of interactive process does the employer need to engage in with the applicant, with the injured worker?
Well, there's no exact set of rules because every situation is going to be different. But the employer has to look at the essential job functions that you need to perform and then make an assessment as to whether or not they can provide a reasonable, if there's anything that they can do to modify that position to accommodate your restrictions. And if they say, hey, we can't do this economically, it's an undue hardship, that could be a way that they don't have to provide you with a modified position. Or it could be that there's no way you could perform the essential job functions even with modification.
Right.
So there's a lot of things that the employer has to do, and there's a lot of documentation that they have to make to do it right.
Right.
So if your employer is just telling you, hey, we don't have anything for you, just go away, you need to call the injury helpline, get legal advice. It's 844-984-8414.
Right. So these are you talking there about temporary work restrictions and going back to work with those, or about a permanent work restriction that's included in the report, a final report? It's a permanent work restriction and going back with that. What are we discussing?
I think that the outcomes are going to be different in those situations potentially on what you get if your employer messed up. Okay, versus is it a termination? Is it not a termination? If it's but generally the rules are the same. Oh. The employer has to provide reasonable accommodation in the requirements, whether or not you have a temporary report or a permanent work restriction. Your employer has to go through that process.
They do. I think one of the main differences between a permanent restriction and a temporary restriction is if your employer cannot accommodate, and they've shown reasons why they can't, such as Alex described, why they legally can't accommodate you and they just don't have a job for you, now you might be let go, and it might be okay for them to let you go. However, they must provide you with a voucher.
Right, and that you become entitled to the job retraining.
Correct. So you get that voucher, and that voucher,
if it's permanent.
If it's permanent.
If it's temporary, you get temporary disability.
Correct. And once again, that voucher, it's given to people that can no longer go back to their old job. So now they need retraining. They need money to go back to school. Right. They need money while they're studying. So it's a really, really good thing. That voucher is very important. A lot of people forget about it. A lot of people don't fight for it.
Or don't
know about it. So that's why you want to talk to someone that has been doing this a long time, and they'll fight for that voucher for you. So
that makes the difference in a settlement with a lot of my clients.
Right.
So we'll present, and George, I'm sure this is true for your practice as well. You present the settlement to your client. There's a certain amount of permanent disability. Hopefully there's not too many permanent disability advances, which we talked about in the last episode. And then there's suddenly a voucher. Hey, you're entitled to, it's going to be $11,000 in total,
right, to
help you get retrained. And that's a big difference in a settlement for a lot of my clients.
Hey, that's a big help. And that might, maybe a silver lining. It might push you to go back to school to learn that trade that you've always wanted Absolutely. To, but didn't have time for. So, it could be dental assistant. It could be even to start off a nursing career or something, whatever you're interested in. It could be a trade job. You can go to carpentry school or something like that. But the nice thing is that it's money given to you to be able to start over, right? To do something that with your work restriction, permanent restrictions, you'll be able to move forward and kind of build a career from there and be able to get back on your feet. So it's nice. And it's something, like Alex mentioned, people might not know about. So
we're going to put a link to the video in the description below. And so that you can go ahead and check out more information on the supplemental job displacement voucher. That's what you get if you have a permanent work restriction that your employer cannot accommodate, if it's work-related, if that's conditions work-related. If it's a temporary work restriction and your employer can't accommodate, then you get temporary disability benefits until your medical treatment concludes to a point where the permanent work restrictions can be understood by the doctor and then given to you to give to your employer.
Yeah, and listen, Alex, you made really good points. And obviously, we always say knowledge is power. If you know something, you're able to get what you deserve. And that's why we're here, to impart knowledge and also with our knowledge, fight for you to get what you deserve. But something very interesting about that voucher, Alex, is that although someone might be entitled to it, right, they are able to fight for their right for it. If they don't know about it, they can't do anything because you can't fight for something that you don't know you're entitled to. Now, the reason I say this is because there's been changes in the law to where you can't settle out a voucher in some instances, and even if you have a CNR, and the defense attorneys, and they're just doing their job, they're fighting for the insurance company, might, if the other attorney's a no, or maybe it slipped his mind, might just bury it in there to where they might not cancel out the voucher because the judge is going to object to that. But the voucher kind of gets lost in the process if you don't have an attorney that's going to fight for that for you. So it's your right, you're entitled to it, but somehow it's never brought up. Maybe you get a good settlement and they never even discuss that with you. I've actually done settlements where I fight for the voucher, even if we haven't got to a point where they're entitled for it. It might be the make or break it point. Maybe you've negotiated for a good amount of settlement, but your client's kind of still on the fence, and you can let the defense attorney know, listen, we might be able to get this one wrapped up, but you have to give my client more. I want more for my client. You have to agree to do the voucher, even though my client's not entitled to it, and you might get it.
Not yet entitled to it.
Not yet entitled to it.
There's an argument that they could be, maybe.
Correct.
And we don't make any attorney's fees on the voucher.
Nope.
So when you get the voucher, we're doing that just to help our client.
It sounds like something that, someone might say just to obviously sound good, but I seriously try to do the best for my client on every case. If a stip is better for them, we discuss stips, look at our video, then I will push for a stip and I'll explain why it's better for them.
You mean leaving the future medical care open?
Leaving the future medical, some cases.
And we've done a video on this.
Right. And some cases warrant that. If settling everything out is more beneficial to them, we'll proceed with that route and we'll always fight for the most. We'll keep on fighting until we get something that we believe is fair or even more than fair for our client. But if you don't know, once again, knowledge is power. If you don't know how to do that, and if you don't know what your client deserves or might be able to get and take it to the max, then you won't be able to get that for your client. So that's why we're here,
That's right. So if you're out there and you're wondering what's going on with your situation, you have a work injury and you're being returned to work, this is when a lot of people out there call us. A lot of workers call us at this point. That's why we're putting this video out there. You can dial the injury helpline and get legal advice. It's 844-984-8414. Remember, this video is general information only. It's educational. It's meant to help you, but it's not legal advice. That concludes this episode of the Inland Empire Workers' Compensation Lawyer live stream podcast. Remember the injury helpline, 844-984-8414.